Okay, we'll get started in about a minute. Okay, we have 71. The attendance is running. Please sign in when you can. All right. All right, another 30 seconds, we'll get started. All right. I think we have 70, which is probably close to capacity. Everyone hear me okay? Just give me a thumbs up. All right, excellent. I hope everyone's doing well. Any questions before we get started? Anything on your minds?
I know we've asked
Wait,
about
wait, who, I'm sorry, who's talking now?
like
You just raise your hand first, I'll call on you. I don't like when people start talking without me seeing who they are first. Okay. All right, Blake. All right, now you can go ahead. All right, what's your question?
so I know we've asked about exams a little bit in some of our previous classes, but I think that the release of the email that we had recently doesn't really affect ours too much. We already knew it was going to be open notes. It's staying with the 3-hour process with example 5. So really, that email doesn't change hardly anything in this class, does it?
Not much. No, I'll talk about your exam next Tuesday, a week from today. I'm going to do a final exam review session. Thank you, Blake. So 1 week from today, I'll do a final exam review. I will walk you through the final exam from I think it's 2018, the spring semester, and I will explain as best as I can how the testing will be conducted under these unique circumstances. But for your purposes, plan as you were. Not much changes. There'll be some changes, of course. It'll be a little bit different, but whatever you were doing before should stay. I've never given a multiple choice exam in my life. I don't like them. I don't think they're particularly fair. Actually, my camera's off, so I'm adjusting. See my arm going up. I don't like multiple choice questions, so I've never given them. Also, all of my old exams are online. I don't keep them a secret, so I don't really care if you share them. It doesn't really matter to me. The only difference is cheating's easier, and that's a fact of life we're dealing with. So, but yeah, Blake. So just keep doing what you're doing. That's a short answer. But yeah, hopefully you all read the dean's email, which gave you some guidance. We had another 3-hour meeting. I can't keep track. We talk a lot. I've never had this many faculty meetings in my 8 years at this college. Never. It's like all of a sudden people have all this time in the world. We just talk for hours. But I think we eventually reach a good resolution, which we don't always agree with, but we're content in the resolution we've reached. I think that's the only fair way of doing it. Okay. All right, any other questions before we get started? All right, and if you haven't, just rename yourself last name, comma, first. I think most of you did, but a few of you didn't. And that just helps me sort you better for the recitation. Okay. Let's start with a poll question. Let's see if I do this somewhat quickly. I can. So it's going to start in. There we go, resume. Okay. All right, so here's your question. It should show up on your phones now. Okay. L leases Blackacre to T. T then assigns his interest in Blackacre to S. S fails to pay rent and is judgment proof. L can sue T for the rent S failed to pay. True or false? Okay. true or false. So take another 30 seconds, think about that one. Okay, another 15 seconds. Alrighty, let's take a look at the roll. Okay, who is the next person that's up?
It should be me.
Who is that? Is that Garrett?
Yes, sir.
Okay, thank you so much. All right, so let's just take it one step at a time, Garrett. Let's look at our question again.
Okay.
What does it mean to assign an interest? What does that phrase mean?
It means you give all your interests completely to a third party.
Now, is this giving a fee simple?
I don't believe so.
What exactly is the interest that's being given? You're right when we say full interest, but full interest in what? Just let's be precise here with our terminology.
Is it the present interest?
The present interest in what? Go look at the question. Go look at the question.
Oh.
The present interest in what?
In Blackacre?
Okay. Does T have a fee simple?
Then I think so.
What's a fee simple?
It's when you have complete rights, both present and future.
Does he have any future interest in this property? What was given from L to T?
I guess it is fee simple.
No, that's not right at all. At all. Garrett, who's next? Jenny, you here? Jenny, what interest was given here? What interest did L give to T?
The lease, which would be a present interest.
Is
possession.
that fee simple?
I don't think so, but I don't know what it is.
What is fee simple? Oh, I didn't think I'd have to review this today, but what does fee simple mean? This goes back nearly a month. Please don't put the answers in the chat. You're not helping anyone.
Fee simple is both interest, future and present.
Okay. What kind of interest was given here?
Just present.
For how long?
The term of lease.
Okay, very good. I'm somewhat concerned now that this is not hard. A fee simple is the full bundle of sticks, both present and future interests, right? A lease isn't a fee simple. Indeed, the phrase fee simple has nothing to do with leases. We have freehold estates, which is like a fee simple or a life estate, and we have leasehold estates. Freehold estates are completely separate from leasehold estates. The rules governing leases are completely different than the rules governing freehold estates with life estates and future interests. This is a very basic point, and I'll make this bluntly. I do tests on this. Maybe you don't care anymore, but I do tests on this every now and then about what the difference is between leases and freehold estates. And if you start applying leasehold doctrines to freehold estates, you're wrong. Okay? So the answer here has nothing to do with fee simple, right? So I'll try this one more time. L gave T a lease. T assigned his interest to S. So T gave everything he had, which was simply a leasehold, right? For some duration. I didn't put the question how long it is, but we can assume it's a year or 5 years, 10 years, whatever it is. But T gave whatever interest he had to S. Okay, then the question is S fails to pay rent, and we find out he's judgment proof. That is, S has no assets he can't be collected from. The last sentence reads, L can sue T for the rent, right? L can sue T for the rent. It's Alexis, right?
Yes, sir.
Can L sue T for the rent?
No, it's false.
Why is that false?
Because in an assignment, since the tenant gave up all his interest, since the tenant gave up all his interest in his lease to the assignee, it's only going to be the landlord and the assignee, and the tenant's out of the picture.
That's exactly right, Alexis. What's lacking between the landlord and S? By the way, L is landlord, T is tenant, and S is sublessee, right? The subtenant, right? What's lacking? Why can't the landlord sue S? What do they not have? What's that word? What do you need to sue someone? What's that word? Comes up over and over again.
I think I'm a little confused because I thought L can sue S, he just can't sue T.
I'm asking you, what's lacking between L and T? You're right. L cannot sue T. Why? What's lacking between L and T?
Because T doesn't have a lease anymore. He doesn't have a privy of contract.
Privity. That's what I'm looking for. Very good. Right? When T assigned his interest to S, right? When T assigns his interest to S, T is out of the picture, right? There is no longer privity between landlord and T. Therefore, the landlord cannot sue T. The only person the landlord can sue is S. So the answer to this one is false. 66% of you got this one correct, but a third got this one wrong, which is not very good. Blake, I'll get you in a second, I promise. From last class, you should know the difference between a sublease and an assignment, right? With an assignment, T is out of the picture. A landlord has no privity with T, and therefore he can't sue T. But if there was a sublease, the question's different. With a sublease, T would still be in the picture. He still has some retained interest. And the landlord can always sue T if S fails to pay. So this question, whether it's true or false, turns on the distinction between a sublease and an assignment. Okay, Blake, go ahead.
In that question, when you say that S is judgment proof, was that just to eliminate him as a possibility? Because when I read judgment proof, it made me feel like there was like a missing fact that T didn't do a full assignment for some reason to S and maintain the ability to be judged.
Oh, no, what I was trying to get at is the landlord tried going after S and couldn't get it. So then he went to T as a backup.
Okay, so that was just more than less a qualifier for this particular question, not something that would typically
Right.
happen.
Right. The reason why I put that fact in there, Blake, is to explain the sequencing, right? As a general matter, the landlord should start by going after the current tenant, right? And if for whatever reason the current tenant can't pay the bill, then he can try and drag in T, the intermediary, with the sublease, right?
So
You don't
from
start...
a realistic standpoint, S really, in most circumstances, wouldn't necessarily be judgment proof right off the bat.
Maybe not. But I put that fact in to make it clear he at least tried to go after S first, and it failed.
Okay, that's what I missed. So,
Okay.
thank you.
Chance asks, is privity a term of art that needs to be used in an essay? It's a word. It's a word that describes several concepts you've had in other classes. So if the case involves an assignment, you should mention privity. Yeah. Douglas says chance. I think he's okay talking about chance. All right, Deanna, I think your hand's up. No?
So what are the options for L now?
L's out of luck.
So I know. I'm sorry. So does that mean S has to file for bankruptcy and then there's a bankruptcy against him because L can't go to T, so I don't.
Well, look, I mean, this is one of the risks when you select a tenant, right? If you permit an assignment, you run the risk that the person who is assigned is judgment proof. And the landlord maybe have luck. Bankruptcy is a class you'll take probably later in law school. Bankruptcy proceedings can take a very long time to resolve. It's very likely that L may never get his rent money back, which is why you have things like security deposits, that if a person fails to pay rent, you may be able to take it out of the deposit. And that's actually a very good segue to our topic for today, right? The guarantee for rent isn't on a person's reputation, but the fact they put maybe a month or two rent up front. So if for whatever reason they're 2 months back, you just take it from the deposit. Thank you, Dana. Other questions? Dylan asks, are assignees required to pay security deposits? In some cases, yes. It's possible that the original tenant already put down a security deposit. If there's an assignment, the original tenant would get his deposit back, and the new assignee would put down his own security deposit, right? Because the security deposit is personal to a given person. With a sublease, perhaps not. It's possible that the original tenant keeps his deposit in place. But landlords will not let someone move in unless someone has a security deposit that's on file somewhere. Okay. Yes, Nancy, go ahead.
Sorry, I couldn't tell if I'd unmuted myself. So I understand the privity concept. Is there would it be incorrect to include in an answer that T didn't retain a right of re-entry?
Well, I
relate to T?
Yeah, no, I think you're thinking of that last case we did in the class last week. Generally, if I say assigns and I don't give any other facts, that means he assigns the entire interest, right? Generally, assigns is short for assignment. If in fact the tenant retains the right of entry, that's not an assignment. That's basically a sublease.
Right, but I'm just saying, like in a written answer, for us to say he can't sue him because he's retained no right of reentry. That's just a partial answer, I guess.
Yes.
The more full answer would be to say there is no privity of the contract.
That's exactly what I'm looking for, right?
Okay.
Or let me put it a few more clearly. I would say T assigned all of his interest in Blackacre. He retained none. And because he assigned all of his interest, there's no privity of contract between T and the landlord. Therefore, the landlord cannot sue T. There's no privity. And Dana writes, my roommate assigned her part of the contract and they assigned her to pay deposit. Yeah. Usually when there's an assignment or sublease, more money is going to be exchanging to make sure that someone has backup. But really, the only guarantee against a tenant not paying rent is a deposit. That's what's there. You can always kick them out, but generally by the time you're kicking out a tenant, they don't have money, so you can't get it from them. You can't really collect from them. Adam, yes, sir.
So
you're breaking up, my friend.
You just asked if it wasn't an assignee, what kind of wording should we expect to see that we'd know if it to distinguish between an assignee and a sublet, like?
Well, I can ask you this a couple different ways. One, I can just say he assigns it or he subleases it, right? I can do that. Second, I can just say he gave his interest to S, but he retained a right of entry, right? That's Nancy's question a minute ago. And if I discuss retaining right of reentry, that suggests it's not an assignment, but that suggests it's a sublease. So I can either just tell you what it is, or it can give you facts which will hint at what it is. I can do it either way.
Perfect. All right, thank you.
Yeah, thank you. Nick asks, this is long. If a lease is completely silent and a lessee's ability... Nick, you want to just read it? I don't like reading long questions on chat. I feel like I'm not doing my job.
I was saying, if a lease is silent on the ability for the lessee to give an assignment in a sublease, what presumption is there? Is it that they can't give it at all if it's silent and it mentions nothing about it?
I think the general presumption is it can be withheld. A consent has to be required to give a sublease. That's the general rule, right?
Okay.
I mean, it's difficult to imagine a lease that's silent, but the presumption is you need some permission to give out a sublease.
Okay, that answers that.
Stuart asks, can landlords place liens on tenants? You'll learn about liens when you take secure transactions. There are different types of liens, and they're very complicated. But generally, a landlord is not really a secured creditor. There's not like any sort of collateral. You don't put your lease on like some piece of property, right? Generally, these are people who have just 2 months rent, and you're not going to get more than those 2 months rent. That's probably all you're going to get. But good question. All right, other questions on the provocative poll question? Wasn't supposed to be, but turned out to be. Okay. All right, let's start then. We're almost done. It's kind of spooky. This is just such a weird semester. It's so strange. At least I got to know you all like pretty well before we had to go off into Zoom land. It's gonna be strange in the fall. I think there's a good chance if we start in September, we may not finish in November. We may have a disrupted semester again. I don't know. At least I got to know you well enough. There are going to be summer classes being taught where you'll never meet a professor, in person at least. How many of you are taking summer classes? A lot of you? Yeah, a bunch of you. Was it Torts 2 or I'm sorry, no, you took Torts. Property 2? Yeah, a lot of you are. Well, I wish you luck. It's going to be tricky, but we'll push through. All right, the topic today for our second to last substantive class is about landlord-tenant relations. And the cases today concern situations where stuff goes wrong. Today we're going to have cases where the landlord screws up, right? These are cases where the landlord makes errors. So let's start with very basic elements of a lease. What happens when the tenant doesn't pay rent? The landlord can always file a lawsuit for back rent. The landlord could also seek damages due to a breach. What if the tenant is still in possession? You have what's called eviction, right? Where the landlord can terminate the lease and try to reclaim the property. Easier said than done. We'll talk about evictions in the next class, but the short answer is it's very difficult. Evictions are not simple. And the reason why is that there's a lot of judicial process before a person's removed. And some of this process, I think, makes a lot of sense. Often there might be a dispute, right? There's a disagreement over what rent is actually owed. Maybe they paid the rent, but the check got lost in the mail, right? There might be reasons why a prompt, quick eviction is a bad idea. But above all else, the security deposit is what guarantees the landlord, right? Usually security deposit is 1 or perhaps 2 months rent. Why 1 or 2 months rent? Because that's usually how long it takes to evict someone, right? Let's say a person fails to pay rent month number 1, and then the landlord moves to evict them. It might take a full month before they're kicked out. So the 2 months rent is more or less an anticipation of what happens if the person defaults, says breaches are due to pay. They're already covered for 2 months. If for whatever reason the eviction takes longer than 2 months, then the landlord might be on the hook for the lost rent. Someone asked about liens a minute ago. Generally, people who are being evicted from apartments are, as they say in the business, judgment proof. They don't have money. They had money, they pay their rent. So it's like trying to squeeze water from a rock. You're not going to get anything out of a person who has nothing. So it's usually not worthwhile to sue for back rent because you'll never get it. right? I a couple of years ago, I was in a car accident. Someone hit me, and the person had no insurance. I realized very quickly this person had no money to an old beat up car. And I said, all right, whatever. I just let my insurance cover it. And the insurance asked me, do I want to go sue them to try and collect? I'm like, nah, let it go. Because this woman obviously didn't have money. She had no insurance. She had. Sometimes there's no point suing a person who has no money. You're going to just waste your time. So often with landlords, if they're evicting someone, they're not going to bother suing for back rent, but they can. They're in that right. Okay. Yes, Sheila, go ahead.
Yes, because I always have questions.
Please.
So, to the point that you just made, that oftentimes landlords find it unnecessary to sue the tenants or the former tenants for the back rent. Is that why instead, like, I don't know, I guess it doesn't make sense to me, because don't they put it on like the person's credit and it shows that you have like,
oh yes,
because you're not a person who pays their bills on time?
Oh yeah, they'll send it to collections, right? Right? Okay, thanks, Sheila. So let me just clarify. The landlord can hand it over to a collection agency, right? And the collection agency will put it on a person's credit report that there's a lien or a judgment against them. My point is, they may not take the time to go to court to sue for a person who's never going to give it, right? The way collection agencies work is basically the landlord tells the agency, all right, John Doe owes me $1,000. I'm going to assign the interest to you, and you'll get to keep, whatever share of it that you want and pay me the rest, right? And then the collection agency is the one who actually goes after them. It's not the landlord who's suing them, if that makes sense, right? I had this thing where I randomly got I never got the bill from a company that I did business with, and I got a random collection notice, and I said, what is this? I never got the bill. The original company is basically piecing out, like, we don't care. They'll just sell it for a very low price to the collection agency, and the collection agency will try and go after the person. But that can take months and years, much longer than just to evict the person. Make sense? But what the point I was trying to get at is, the landlord is not banking on a person who's evicted ever actually paying, right? It's more just sort of leverage and threat. Maybe they will, but it might be many years on the road. Diana, only because you won't be teaching it in the case of a sublease, it won't be in the tenant's credit. I think those are two messages. In the case of a sublease, it won't be on the tenant's credit. Depends. Sometimes when you have a sublease, you put your credit on the line, and if there's a problem. But if you do have a sublease, and the person you sublease it to decides not to pay the rent, you may be in trouble also. So it's always risky when you actually approve a sublease, because you are taking on the credibility of the person you're subleasing it to. Okay, questions on that? All right, a few other points. Security deposits have to be kept in what's called a trust account. A trust account. What does that mean? The landlord cannot put the security deposit in his personal checking account or his business checking account. Each security deposit is basically in a separate account, and that account must draw interest. Why are they in separate accounts? To prevent what's called commingling. Commingling. This is a word you need to know as lawyers. Commingling. Commingling is when a landlord or someone mixes his money with a tenant's security deposit. You cannot do that. Each deposit is its own account. If there are any deductions, you have to itemize the deductions. And there are severe penalties for withdrawing from it. Hopefully all of you will become lawyers in a couple of years, because we'll have a bar exam once again and we'll be back to normal. True. Hopefully. And you're going to have clients. And what happens when a client gives you a retainer? That is, gives you money up front for services. They'll say, okay, Josh, we'll give you $10,000 and you deduct it as you bill hours. Each client has to have a separate trust account. It actually operates sort of like a security deposit. It has to earn interest. And if at the end of the client representation there's money left over, you return whatever's left over to the client, right? Let me tell you this bluntly. The easiest way to get disbarred, right? You're working hard for your law license. The easiest way to lose it is to steal client funds. is to take money from a client account improperly. It's the easiest way to get disbarred. Why? Because it's easy to prove, right? Each client has a separate account, and if you make a withdrawal from that account, it's a matter of record, right? The bank has that record. So it's a very easy way to get disbarred. Don't do it, right? Just do the right thing. Don't screw up, right? The bar publishes every so often a list of the attorneys who are removed, right? It's public. You can, they actually publish the names, and they explain why they're removed. And it's very often mismanagement of client funds or something like that, because they basically not quite stole from the client. But even if you borrow, say, I just borrowed $1,000 to cover my rent and I put the $1,000 back in the following week. No, you can't do that, right? That's theft. Every penny must be accounted for in the client accounts. If you don't want to have trust accounts, don't take a retainer. Just bill them after the fact. But bill them after the fact and they never pay you. All right. Lesson learned. Yes, Stuart.
So I always thought of trust accounts as where you kind of pull assets together, like real estate or bonds, stocks, and all that. How does that work for attorneys? Is that the same?
That's not what a trust account is, right? I mean, people use words in imprecise fashion. So what you're describing is often commonly called a trust account, but in the context of security deposits, in the context of attorney retainer funds, a trust account is where each client has a separate number. And the banks create these. They'll create them for you, right? And the bank will basically segregate the funds in person X's account, and you basically add money. So let's say your client sends you a check for $5,000. You deposit it for trust account number 1234567, right? You deposit for that number. And then when you bill some hours, you withdraw from account number 1234567, right? You take it from that specific point. And you actually have to give your client an accounting, like a statement, every so often of what's in their trust account. If the client ever calls you and says, I would like an accounting of my trust account, the answer is, yes, I'll get to it right away. Because if you sort of like, I'll do it next week, then they start flipping out. So it's always, you do it. Ricardo asks, is a trust account similar to an escrow account? Not really. With an escrow account, a third party holds it. With a trust account, the lawyer supervises it, but he has access to it in theory. Troy asks, is a property owner required to have an account per lease, per property, or per tenant? I think, frankly, it's actually per tenant. So let's say you have two roommates in a unit, and they each put down a separate security deposit. Each deposit collects interest at a different rate, right? Because let's say one tenant stays for 1 year, and the other tenant stays for 5 years, right? The 5-year deposit will accrue more interest because he's been there longer. So I think each deposit, each individual tenant has his own account. And banks create these. It's not, not easy, but it's not like as complicated as opening up a new account for every person, right? If you go to the bank and open an account, you have to do all the paperwork. Bank streamlines make it easy when a client comes in, you just open a new trust account for them. It's not terribly complicated, but you have to be very careful, because if you screw up and commingle funds, you will be in trouble. Because there's one thing clients know. Clients don't always know if they're getting good legal services because they can't really assess it for themselves, but they know if they're getting screwed financially, right? Clients will know if you're billing them wrong. That's one of the few things clients will be intimately familiar with. So that's why it's very easy to get in trouble that way. I always mention this point when I teach landlord-tenant relations, because you will all be lawyers in a couple of years, God willing, and we'll be there. Nancy asks, what is the importance of interest? The idea of interest is that you are giving someone money to hold for you, right? Let's say you weren't giving that money. You could hold it for yourself, right? The idea is the landlord is not supposed to profit off of that amount. So imagine that you give the landlord that money and he starts collecting the interest for you. That's not appropriate, right? Whatever benefit from money sitting around goes to the person it belongs to. In theory, after a lease is over, the tenant gets the security deposit back, in theory at least. And if there's any interest, the tenant gets the security deposit plus interest. Now, I have never gotten back a security deposit in my entire life. Ever, ever, ever. I had a dog for many years. and she peed on carpets. So I've never, I've never, ever gotten back a security deposit in my entire life. Indeed, I would usually have to pay extra money to cover all the pee stains on the damn carpets. I've replaced so many carpets. Like I had one apartment where I just moved in, and there was a brand new carpet. I'm like, oh no, they just replaced the carpet. Damn it, it's brand new. I want an old one that wouldn't be as expensive to replace. Anyway, yes, Nancy, I see your hand.
So I've lived in the same place for the past 4 years, and I plan on living here until I'm out of law school and in a job. And I've just paid one deposit.
Good for you.
So all of this time, it's theoretically accruing interest. In theory, I'm supposed to get that. I would have never known that. I've never gotten anything. I've always gotten my deposit back, but never gotten more than what I paid. So what is a tenant's
well,
probably not worth it to pursue, right?
They're supposed to pay you interest. It's a very little amount. I don't pretend it's a lot. We're talking pennies here. So maybe the amount was so small that they just rounded down if it's, a year lease. I mean, you're not getting a lot of money, but they're in theory supposed to be something. If your landlord, I think when I got my deposit, they were like $20 off. Like they said, I owed them X, and I actually it was X minus 20. There was some disparity. I could have sued, but I didn't really care. It wasn't worth my time. So that's my short answer. Most things aren't worth time to actually pursue. But you should get interest, at least in theory. And in theory, you could ask your landlord for an accounting at any point, saying, what's the value of my trust account? They'll look at you like you're crazy. But in theory, you could ask them that.
Yeah, but the best part of the landlord-tenant relationship is having that rapport. When you start doing that and making it sound like you don't trust them, then
right, yeah. I mean,
things start to break down.
Right, which is why, if you ever notice, I always say, like, don't worry about stuff. I don't mean that to be, like, lazy, but the cost of resolving minor disputes is often not worth it. And landlords know this, and tenants work. That's why I don't read my lease. It's like, what do I care? Right, I'm going to sign it anyway. Right, I'm not going to read this thing. What difference does it make? It makes no. I don't know. If I start complaining, it'll just make problems. And if there's ever actually a dispute, people usually work things out irrespective of the lease. They'll just figure a way around it. I'm a terrible lawyer, I know. But for the most part, these things don't really matter. They matter when conflicts arise. And by the time conflicts arise, the written instrument is already not very useful. A few other notes on the deposit. Very often, landlords try to get around the 2-month limit, and they'll charge what are called liquidated damages. Liquidated damages. You might remember this phrase from contracts. Liquidated damages is when you stipulate in advance how much a breach is worth. So let's just say the lease says, if the landlord fails to pay rent, there'll be a penalty of $5,000. Right? It's set in advance. Okay? That is a penalty, and that's not the security deposit. So in other words, the landlord can't take your security deposit and apply it towards the $5,000. They would have to sue you for the $5,000 separately. Right? So there often are litigation over whether the money they're asking for is part of the security deposit or as part of some sort of damages or penalty. And if it's part of the damages or penalty, they can't take it. The deposit, in theory, is meant to just cover damages to the apartment and unpaid rent. It's not supposed to cover additional things like a liquidated damages clause. Any questions on that? Those are rare. You don't see those too often, but they do exist. One other point the book discusses is something called rent acceleration. Rent acceleration. I actually had this on my apartment when I lived in law school. I think it was a 14-month lease or something. And the clause basically said, if you fail to pay rent for 1 month, the rent for the entire term is due immediately. Right? One more time. So if it's a 14-month lease and you default on month number 1, you immediately have to pay all 14 months rent. This is upheld by courts. It's a very brutal remedy. and it creates a huge disincentive to breach. No, and Garrett asked, "You get to keep it for the rest of the lease, though?" No. If there's acceleration, the landlord can't take possession as well, because you're basically prepaying rent for the entire term. So it's basically the landlord saying, "You can still live here if you pay me everything," but frankly, it's very difficult to pay 14 months rent at once. I mean, if you think about it, if you can't pay 1 month rent, how on earth you can pay 14 months rent, right? It's not going to happen. So I don't think I did not breach my lease, but it's somewhat scary if you have that. I had rented it from a condo owner, and she she was just a one person. This was her security. She said, "Okay, if you don't pay the rent, you're stuck." Anyway, there's that. Okay. Questions on rent acceleration? Oh yes, Troy, go ahead.
For rent acceleration, would that be the same terms as, let's say, if you breach a 1 month rent, can the is it possible to institute a new month-to-month rent amount higher than what it was before?
If the landlord agrees, you can, right? But think about it this way, Troy. If you had a 1 year lease, you're still under that lease, whether you like it or not. So you basically need the landlord to release you and charge a higher rent. So I guess a landlord could do it, but there's a risk. You didn't pay your first month rent, maybe you won't pay the higher rent either.
Well, the reason I'm saying is because wouldn't that be the same kind of like a lease? Well, I guess it's different than lease acceleration, but wouldn't that be the same kind of punishment? Says, it's a deterrent not to breach, because if you breach, your rent could go up by $400 a month.
Oh, I see. So okay, so let me answer Troy's question a little bit differently. Let's say you have a clause that says, "Here's the rent, but if you fail to pay, your rent doubles."
Yeah.
Right. You can have those clauses, right? That might be considered like a penalty as well. But in general, to make this point again, if a person failed to pay the lower rent, they're not going to magically generate money to pay the higher rent, right? It's all this like this sort of game where people who are in bad financial conditions get hit with higher and higher fees and penalties are probably not going to pay. So the remedy almost always is, we'll evict you, then we'll charge you a penalty, rather than increasing your rent hoping you pay it down the road, right? The remedy is probably going to be, we just kick you out and hope to collect later. This was sort of Jayla's question a few minutes ago. Make sense? Okay. Chance argues, can you argue that those punishments goes against a matter of basic what? I don't know what that is. That's not a word we use in property. The F word. I don't use that word in my class. No, Chance. I'm mostly joking here. Historically, property law has been very, what's the phrase the book used? Hard-hearted and hard-headed? I don't know, whatever. It was very rough, right? Historically, landlord-tenant law was very pro-landlord and very anti-tenant. That's changed in the last few years. It's become much more pro-tenant. I don't know if it's at equal parity, but it's much more pro-tenant than it was years ago. So there are some courts that would protect tenants from being evicted in this case. Nick asked, would some court consider that a punitive damage to have a liquidated damage? Yes, if the amount is so out of whack, right? If the amount is so much higher than the rent in the lease, you can actually declare it punitive damages and say it's unlawful. So courts will routinely strike up penalty clauses. Imagine your rent is $1,000 a month, and it says if you fail to pay your rent, there's a $50,000 penalty, right? Okay, that's insane, right? You would say that's a punitive damage. Would be you can't have a penalty that's 50 times what your monthly rent is. Chance, I don't know what's on page 514, but I'll check on it later. Okay, let's move on. Again, historically, landlords only had a duty to warrant the fitness, the physical. They did not have a duty to warrant fitness, right? All a landlord gave was legal title, right? That was the sort of common law rule. But in the modern context, landlords have duties that things have to be habitable. They have to be in certain kinds of conditions. Okay. Now, what happens when a property is in a bad condition? Can the tenant stop paying rent? Can the tenant pay less rent? Can the tenant vacate? When I say vacate, I'm talking about get out. Like the word vacation doesn't mean like you go on a trip to Florida, or none of us going anywhere now. For me, a vacation is like go to the mailbox, right? But pretty much. But a vacation is when you get out, right? What exactly can a tenant do when there are problems? And that's the subject of our first case. Tim, I think you are next on the list.
Yes.
All right, Tim, you want to walk me through the facts, please, and I guess it's our only case. Village Commons versus Marion County's Prosecutor's Office, Indiana, 2008.
I have Berg v. Wiley.
Oh,
for the first case.
Did I screw up? One second. Oh, okay. No, I did. Okay. Huh. Okay, I'm sorry. I was on the lecture notes for Thursday. Look at that. Well, Josh screwed up. Okay, give me 1 second. I'll pull up the right one. You know what? Then just start giving me the facts in Berg, and I'll catch up, and I'll just get my right document open. I was reading. I'll tell you a funny story first before I let you go. I think it was my first year teaching, and I was teaching Property 1 and Property 2 in the same semester. For whatever reason, I thought I had Property 1 in the morning and Property 2 in the evening, and it was just because 1 comes before 2. There was no actual thought process there. I just had them flipped in my head. Turns out they were reversed, and I walk into the class and I asked the very first question. It was on a Property 2 case. It was in Property 1, and people were like, "What the hell are you talking about?" So I've done this before. Okay, Berg v. Wiley. Okay. Oh, that's why nobody knew us.
To get the approval.
No, she didn't. Yeah.
Yeah, and then there's also issues with the health department.
Right.
In the kitchen, and they gave her a certain amount of time to fix it. But in the lease, it said that she had to operate the property in a manner in accordance with the law.
Good.
So Wiley used that as grounds to evict her. He went in after hours when she wasn't there and changed the locks. And that's why she's suing him.
Yeah, so this case was kind of creepy, right? Thanks so much, Tim. That was very good. And I'm sorry, I said the wrong case. I was thinking of your class for Thursday. And Thursday, you are doing Village of Marion. All the stuff I said before is all correct. I didn't say anything wrong, but I had the wrong case in my mind. So I do apologize for that. All right, so this is a case involving what's called SelfHelp. Right, SelfHelp. SelfHelp is a term you probably know from torts, in which the parties try to handle their disputes privately without going to the courts. And let me tell you, the courts hate SelfHelp. The courts say we are the ones to resolve disputes, don't handle it yourself. So we had a situation here where the landlord had a lease that said you need my permission to make any sort of alterations to the property. Don't make any change with that permission. And the release also said, I reserve the right to retake possession. A restaurant was opened. They sold beer, it's kind of like a bar, pool hall type thing, right? And then they had some health code problems, right? They had some problems with the health code. And we all know this, right? They put a sign on the door that says closed for remodeling. They also fired all their employees, and they closed their restaurant. And we know what that means. When a restaurant says closed for remodeling, that means they're shutting down. At that point, Wiley came in and he tried to change the locks, right? And there's this one creepy part where he was sort of like hanging off the awnings, looking in, right, like Batman, right, trying to gain admittance. He was banging on the door. So then Berg Yeah, that best part. It's kind of creepy. It's some dude hanging off your Spider-Man, maybe, right? Some dude is hanging off the awning, peering into your window, banging on the door. And so at that point, Berg calls the sheriff. She's like, "What the hell? This is my place," right? And then Wiley calls the police. And you can imagine, Berg says, "I have a lease here and my landlord's hanging off the awning." And then the other guy says, "Well, I'm the landlord and she made alterations." And the cop's like, "What the hell? This is not a problem. Just don't do anything till Monday, right? Just keep everything for the weekend." Wiley enters without Berg knowing it and then changes the locks on him. Keep in mind the lease still had, I think, another 2 years on it, right? As till 75. So at this point, she was locked out, right? She was basically evicted. And she sues. And she argued the lockout was wrong as a matter of law. Right, so the first issue, who do we have up next? There's Tim. Giancarlo, are you here? Giancarlo? Nope. Jasmine, I think I saw your name earlier. No, Jasmine. Okay, try it again. Carson, I think I saw you earlier.
Yeah, I'm here.
Okay, so Carson, first off, what does the court say about the common law doctrine of self-help? Do they like the self-help doctrine?
The appeals court did not, no.
Why not?
Well, it said that it almost promoted a vigilante kind of theme into where you would take matters into your own hands, and they didn't want the public doing that.
Yeah, why don't they want the people taking the law into their own hands?
Well, I mean, I think things can get ugly like that.
Yeah.
Violent acts, stuff like that.
Right. So, Carson, what should the landlord have done short of pulling a Spider-Man routine and hanging off the roof?
I think the appeals court said that he should have just went through the courts.
That's right. Thank you so much, Carson. And I think I alluded to this earlier, but the courts have developed a fairly, I don't want to say speedy, I think that's the wrong word, but a fairly rapid process to evict someone. And it's what's called summary eviction. Summary eviction. And at least, I think this was Minnesota, right? I think at least in Minnesota, they say it could take 3 to 10 days. I'll give you the Texas numbers in a couple minutes. But at least in Minnesota, it's a fairly quick process, 3 to 10 days. Okay? And the court says that this summary eviction is helpful to avoid violence, right? To avoid this sort of rapid escalation of problems. And many states have adopted this modern rule, where judicial proceedings are the exclusive remedy. A couple years ago, I had a situation, not for me, but I had an elderly uncle who was living in his home for many years, and he had a lady living with him to take care of him. She was like a live-in aide. And she never paid rent. They just sort of paid her off the books. My uncle died, and she didn't leave. And she basically just kept staying there for months and months. And my uncle asked, "Can I change the lock?" I'm like, no, don't change the locks on her, because she will get you in trouble. So eventually, they had to pay her to leave. She had no lease. She was just basically living there as a byproduct of taking care of my deceased uncle, and they just paid her to leave, and she left. But the short answer is you can't kick people out in that fashion. You can't just lock out the door. Okay. Any questions on that case? I'm sorry again, I said the wrong stuff. Everything I said was fine, but just, people freaking out with the wrong case. I feel bad. Don't worry, I'm ready. Okay. All right. In Texas, let me give you guys the timelines in Texas for the summary eviction process. The first step in Texas with eviction is what's called notice. Okay? Notice. You have to give at least 3 days notice before you file an eviction lawsuit. Right? So let's say I want to evict someone on day number 3, right? Actually, well, be precise. if I want to evict someone, I give them notice today, right? Today's Tuesday. You have to wait 3 days before you file the suit. So let's say I give it to them, Tuesday morning at 9 a.m., Wednesday, Thursday, Friday. So I can file the eviction suit on Friday. So you have to wait 3 full days before you file the suit. And the reason why is during this notice period, you can maybe resolve any conflicts, right? Maybe the maybe the tenant made a mistake. Maybe he just forgot to pay the rent. Maybe he was, absent-minded. Maybe he was out of town. But when you get one of those eviction notices, it's like, oh crap, this is serious. Let me take it for real now. So the hope is that the 3-day cooling off period, right? The 3-day cooling off period is enough to avoid having to go to the courts altogether. But let's say after 3 days, the person or the situation is not remedied. At that point, the landlord goes to court. Jayla asks, is that eviction notice the same thing as a pay or quit notice? I'm not familiar with that term. I've not heard it before. It sounds like it. I'm not sure, but I'm not sure. I've not heard that phrase before. Sounds like it though. All right. So step number 2 is you have to actually go ahead and file court, right? So you file court. You file a notice in the court for summary eviction. At that time, you have to serve the citation, right? Right? You have to serve the citation. That's basically giving the tenant official notice that the eviction process has begun. Okay? That generally takes in Texas 8 to 10 days to serve the citation. Okay? The law requires usually at least 6 days notice before the hearing. So an 8 to 10 day citation period usually gives sufficient time. All right, at that point, there's a hearing. These hearings are not very formal. There are usually not lawyers involved, at least for the tenants. Generally, people who are getting evicted from their homes don't have attorneys sitting by. In some jurisdictions, the government or various legal aid groups may provide assistance. There's some law schools that have clinics to help people with eviction work. But there's no right to counsel, any sort of constitutional right to counsel at eviction hearings. All right. So let's say the hearing might last, 20 minutes, 15 minutes, 5 minutes, 10 minutes. They might not last very long. And the judge rules that rent is due. And that there should be an eviction. At that point, there's a right to appeal. Right? The tenant can file an appeal, which usually takes about 5 days. Right? So there's a 5-day period in which they have time to appeal. Those appeals are not usually successful unless the lower court judge made some sort of really egregious mistake. Okay, at the very end, there's usually another 2 days where the local constable, which is kind of like a sheriff in Texas, but the constable must post a 24-hour vacate notice. Usually it's just on the door saying you have to get out in 24 hours. And if the tenant fails to get out in 24 hours, at that point the sheriff can forcibly enter and remove them. The constable enters. Usually this summary process in Texas takes about 20 to 23 days, depending on how you count it. 20 to 23 days for this process to go through. Texas is a bit of an outlier. In Washington, D.C., it takes over 100 days to evict someone. In Massachusetts, it can take up to 2 years. In New York, it can take 3 to 6 months. In fact, New York requires not 3 days notice, but 30 days notice. So basically a full month of notice. So when you have, a 2-month security deposit, if you fail to pay your 1 month's rent and it takes another 6 months to evict you, the landlord may be out 7 months' rent by the time they're done. Landlords know this. And what they'll usually do is they'll just charge more fees, they'll charge higher rent in other contexts to compensate for the fact that you have such a lengthy eviction process. Okay. Question on the timeline. I went through a little bit quickly, but I think that's the general gist. Chance asks, what happens if you have something similar to Berg v. Wiley? One part is acting poorly. Basically, landlord is worried about the tenant is going to vandalize the property. Okay. So the Berg case was a little bit tricky because it didn't involve a failure to pay rent, right? Usually evictions involve failure to pay rent. There was a dispute in Berg about whether the repairs, the improvements actually violated the lease. And that's often an issue that's litigated. So Chance asks, can you go to a court to seek an injunction to block some sort of damages to the property, right? They're going to rip out all the fixtures, rip out all the installation, rip everything out. I guess you can try it, but that's not an eviction, right? That would just be a order to prevent them from removing stuff from the property. I think there's different from saying maintain the status quo, don't remove stuff, versus injunction to evict someone altogether, right? So the key point is just keep everything as it is. I think that the sort of injunction Chance mentioned, I think would be more feasible. Okay. Other questions on the timeline in Texas? It varies by state, and state law is very specific, but these are generally proceedings that the landlord wins. By the time you get to an eviction proceeding, the tenant is usually going to be out of luck. And I think Jayla made this point a few minutes ago. If you are evicted, right, if you're removed from your apartment, you will have a mark on your credit score. You will have a thing saying you were evicted. And that might make it very difficult for you to get a future landlord a relationship, because they'll say, have you ever been evicted? It's like, yes, I have. And then it might be hard to live somewhere else. So there are significant costs to being evicted beyond just losing your current apartment. Okay. All right. Any other questions so far? All right. So the first case involved a situation where the landlord tried to kick out the tenant. Our next one involves a case where the tenant tries to abandon the property. And it asks whether or how the landlord can seek damages, right? Seek damages based on the failure of the tenant to stay there, right? Okay. All right. Nancy, first me a lot today. Very good. I think you're next. Down to the W's.
Okay.
Okay. There you are. All right. You want to give me the facts, please, in the next case, Sommer versus Kridel, New Jersey case?
So in this case, there's tenants who move out before their lease ends.
Oh, give me the facts. The facts in this case are kind of fun. Just go through the actual the chronology, please.
Oh, okay. So you have this guy who signs a 2-year lease, and he winds up breaking off an engagement and deciding to become a student. Yeah. And so he doesn't want to live there anymore, and he doesn't even pick up the keys.
Well, what
you're referring to?
Yeah, that's good. I'll come back to you in a second. Right. So this is one of these crazy cases that law students have a lot of time in their hands, so they do this sort of thing, right? So thank you, Nancy. I'll next person in a minute. You have the defendant, Kridel, who was actually a law student while this case was being litigated, and he worked in the case after he graduated. It took him 7 years and almost $500,000 in fees to litigate this case. Again, people take stuff really personally, and they fight to the bitter end. The case begins where the tenant signs a lease to rent an apartment in Hackensack, New Jersey. And I'm guessing he went to either Rutgers Law School or Villanova. I'm sorry, Seton Hall, which are nearby. The term was for about 2 years. And the landlord gave a rent concession for 6 weeks. So 1 week after signing the agreement, the tenant they paid $690. Okay? And the remainder went for a deposit. The plan was for the tenant to move in on May 1st, but the plans changed. The tenant wrote, "My engagement broke up. Oh no. My parents were supposed to pay the rent after marriage. Now they can't." Right? Basically, the in-laws were going to cover it. As a result, I cannot take possession, and I surrender all rights, and I don't ever want to come in, and I cannot return the key because I don't have it. I'll forfeit the 2 months rent already paid. Please have understanding and compassion. Ryan, was there understanding and compassion here?
Well, wait, what do you mean by that?
Did the landlord show understanding and compassion here?
No, not really.
Not even close.
Filed suit, yeah.
Well, no. Before he filed suit, what did the landlord do here? After the landlord got this note, what did the landlord do?
Plaintiff did not answer the letter.
Okay.
Subsequently, a third party tried to rent it out, and he said no.
Oh.
I'm going to do that.
Why did he not want someone else to rent the apartment?
Probably money.
But if a tenant was willing to give him money, why wouldn't he take it? A new person would come in.
Honestly, I don't know.
Why do you think? I mean, Ryan, just speculate. Right? What did he think was the advantage of letting this apartment sit empty when a tenant might want it?
Maybe getting a double whammy of some sort, having a new tenant and getting the...
Right, but he turned... I get the double whammy point, but he turned the tenant away. He couldn't get a double whammy, he couldn't get a single whammy. Or maybe a single whammy, I don't know. Too many whammies.
Could he collect interest on those payments?
Right, so I'm asking somewhat of an unfair question. I'm not really sure the answer myself, right? But I think the landlord basically thought there was a 2-year lease, and he wanted that money, and he wanted this person to pay. And he was perhaps worried that if he rented it to someone else, he would never get it from this poor law student. I don't know. There seems to be some really bad blood going on between the two of them. All right? So in other words, the apartment sat empty for months. He eventually rented it out. Then the question becomes, what happens to the unpaid rent? Specifically, what should happen when when a landlord refuses to rent it out to a tenant who's willing to rent it? Right? What should happen here? There was also thank you for that, Ryan. There was also a companion case as well from Fort Lee, New Jersey, which is right by the George Washington Bridge, with similar facts. And this case concerns what's called mitigation, right? Mitigating damages. You probably know that from contracts. Was a landlord's duty to mitigate damages, right? Now, Ryan, Doug, you here?
Yes, sir.
Doug, at common law, was there any duty for the landlord to mitigate damages?
So at common law, there was no duty to mitigate the damages. It was a majority.
You're right. At common law, there was no duty, Doug. What court decided this case?
This case was... So the Court of Appeals...
No. Which court decided this case? What was the name of the court? What state are we in?
New Jersey.
So the New Jersey Supreme Court, right?
Yes.
What does the New Jersey Supreme Court do to the common law in every case?
Oh, they overrule it.
And is that what they did here?
It's exactly what they did.
Okay, so what rule, Doug, do they adopt in the place of the common law?
They adopted a rule to where they need to mitigate the damages in order to justify basic fairness.
Good. Very good. All right. Thank you, Doug. Again, we are in New Jersey, my friends, and the New Jersey courts always do the same thing, right? They always reverse the common law. In like every case, in any of your case books, in any class, that's what they do here. The common law rule was that there was no duty to mitigate. If the landlord had a 2-year lease with the tenant, he was obligated to run the entire 2-year lease, and he didn't have any duty to rent it to someone else. If he did rent it to someone else, then he couldn't charge rent. He couldn't double dip, so to speak, right? The double whammy. But if the apartment was empty, he could keep running the bill up. Now, maybe, why did he do this? Maybe the rent in this lease was higher than he could have gotten in the market, and maybe he wanted the higher rent. We don't really know. It's not entirely clear. But the New Jersey Supreme Court reverses that common law rule. And the court makes this point very bluntly, right? The court says the modern approach is to incorporate contract law, contract doctrine into this area, right? Usually property law is very hard-headed and hard-hearted. I think the book describes it, right? It's very mean and very stern, right? But with property in the modern era, we have duties to mitigate. We have implied warranties of habitability. We have these various things the court creates to make property law softer, right? Giving a lease is not the same thing as giving a fee simple interest, and the court treats it very differently. And mitigation is justified by basic fairness. I think that's what Chance asked me about earlier, right? Basic fairness justifies mitigation. Right? The court says antiquated property concepts shall no longer be controlling on residential leases. The court does distinguish residential from commercial leases, right? That is a business lease. They don't quite go so far as to say you need a duty to mitigate for commercial properties, but they sure as hell hint you're going to. So maybe that's the next case. In this case, it was unfairness. The landlord waited 15 months and allowed almost $5,000 of damages to accrue before attempting to let it to someone else. Even though there was an available tenant, the tenant turned her away and let the damages run up the clock. Right? There was no showing that the new tenant was unsuitable. Therefore, the landlord could have avoided the damages, and the defendant is relieved of the duty to continue paying the rent. The tenant can only lose the security deposit, and that's it. Questions on that case? No? I like a few of the facts in this case. Oh, yes, Diana, go ahead.
So if the landlord would have had a reason to deny the possible new tenant, would he have been fined?
Well, that's a good point.
That have been...
Right. That's a good point. Let me address it, Diana. Very often a landlord, when they're picking a tenant, is concerned with a lot of factors. Maybe their numbers are good, but there's something about the tenant they don't like, right? When the New Jersey court says suitable, what they mean is the person's willing to pay the rent that was offered, right? They're not looking at there's a personal relationship, right? In general, due to housing discrimination laws, landlords don't have much discretion, right? They can only turn tenants away on fairly objective factors. Can they have a good credit, or they have any credit history or criminal background? Generally, you can't turn a tenant away because I just don't like the person, right? That very often might be how do I put it, like a code or a pretext that you actually have an improper motivation, maybe race or something else is involved. So landlords in bigger institutions don't have as much don't have as much flexibility to decide who can and cannot enter. But good question. All right, other questions on this case? No? All right. I like a few of the notes about the case that during the litigation, the Kridel based his briefs on Oregon law, and the other lawyer said Oregon law is Oregon's a state and their principal industry is salmon, right? And then after won the case, he sent the lawyer a copy of the opinion and a piece of salmon, and he wrapped the opinion around it. Where there was actually very I guess you have a sense of humor about it. I don't know. I would not recommend that. Sending fish in the mail is not a very good idea. Maybe it's like the smoked salmon. I don't know if it's dried, but not a very good idea. All right. Any questions in that case? All right. Is there anything else? Okay. So a few notes, a few points from the notes afterwards. One topic is surrender. If the tenant surrenders, that is, he vacates, and the landlord accepts that surrender, that basically extinguishes the lease, right? In other words, if the tenant moves out and the landlord says, okay, that's fine, you moved out, that terminates the lease. The tenant can still be liable for some other damages, right? But the lease is basically extinguished, right? The duty to pay rent. But that's going to be rare. Usually the landlord won't say, oh yeah, sure, you can move out, that's just fine. Okay? Okay. Today, I think in 42 states, including DC and including Texas, the landlords have a duty to mitigate. So that's more or less the majority rule now. And the idea is that mitigation reduces different forms of waste. Okay. Any questions on that? All right, let me wrap up a bit and get if you're a little bit early today. When we're talking about leases, when there's conflict, always go to the courts. Do not try to use self-help. There's a summary eviction process that's not fast, but rapid in most states enough that it won't take more than a month or so. But if for whatever reason the tenant does vacate, that does exit, the landlord will have a duty to mitigate and have a duty to rent it out to other people. And if someone's able to rent it and they turn them away, at that point the landlord can no longer collect the rent from the initial tenant. Okay. Questions on this case or this topic?
I have one.
Okay, yeah, go ahead, Alan.
So I know in Texas that I worked for a JP judge before I came to law school, and we did a lot of evictions. So my question is, most of our cases were very simplistic. The tenant didn't pay rent, is very clear cut, and the landlord was allowed to remove them. So like my question is, when it's complex and it's dealing with situations like in the Sommer case, will the JP court just go ahead and expedite it to the trial of the district court, or will they try to handle that matter?
Yeah, thanks, Alan, for the question. And you probably know more about this than I do because you worked in that court. But most evictions are fairly simple, right? And I don't mean simple in the fact that they're easy, but it's the people just aren't paying their rent, and that's a fact of life. When you have these sorts of complicated issues, I think it always starts off in the sort of simple, JP is justice of the peace for those who don't know. But then there's an appeal. I think it appeals to the county court law courts, I think, in Texas. But eventually you get through the ranks and you can even get to the Texas Supreme Court through the ranks. But you have various layers of appeal. Generally, what do you call it? People who are back on their rent, they don't have the money to appeal. They just leave. So those who actually have the money to file the appeal, that's how it goes up the chain. Does that, Alan, answer your question a little bit?
Yeah, that answers it. Because, like I said, most times people usually don't have the money, so they just...
Do they even show up? Do most people even show up to the hearings?
Yeah, sometimes they don't even show up, yeah.
Yeah. And then the judge enters what's called default judgment, right?
Yeah.
Well, Alan, if I could ask, what kind of arguments do people usually make at those sorts of hearings, and how'd they go in your experiences?
They try to really just try to make an argument for like hardship for why they couldn't pay rent, typically. Yeah. But and sometimes the judge would try to mitigate it and ask the landlord whether she'd be willing to accept the rent at a later date. But more than likely, the landlord would just evict them typically.
How often in your cases was a person like not evicted, or how often were they evicted? Most of the time?
Very rarely.
Yeah, I mean, thanks much, Alan. I appreciate your experience in that. The process is designed to be quick, and I'm guessing there were not many lawyers at those hearings for the tenants. Yeah, he's shaking his head no. Yeah, there were no lawyers for the tenants. So there are studies that look into this, that when you have attorneys present, the eviction rate drops a lot. Harvard had I think it was Harvard, one of the law schools in Boston had a clinic where they provided attorneys to people who were going through the housing court system. And they found the eviction rate dropped by some really significant amount when the tenants had counsel. And that could just be clearing up any maybe confusions, or even just saying, Your Honor, maybe we can work it out a different way and make a proposal to compromise. And Alan's judge maybe put together proposals. Not all judges will try to facilitate. They'll say, all right, whatever, evict it next. Because these are quick hearings. Take, what, a few minutes? 10 minutes? Yeah. Okay. Alrighty, anything else? All right, well, we will resume class on Thursday with the Marion case, which now you know a little bit about, perhaps. And hopefully we'll make it to the end of the semester. If you have any questions, I will sign off Zoom now, come back to office hours in a few minutes. Otherwise, I will see you all on Thursday. Thank you so much. Bye-bye. Bye.